Good evening, everyone. Welcome to our weekly Wednesday webinar with the Property Law Alliance. Sorry for being a bit late. We had a bit of technical difficulties, but welcome, Bruno and Greg.
Hi, Marley.
How are you guys doing? How are you guys doing, Bruno?
I'm very well. How are you doing? Sorry.
Good, thank you. And you, Greg?
Fine, thanks so much.
I'm glad to hear that. For viewers, unfortunately, Silna couldn't make it tonight, but she'll definitely be with us next week again. All right, then we can get started. Maybe we should first just discuss evictions in general. Are you managing with your court orders, residential and commercial? Are you still having problems with the sheriff's offices? I think, Bruno, if you maybe can get started on that.
Sure. Absolutely. So as most of the viewers should know by now, Greg, each of us, in fact, so Selma, myself, and Greg, each focus on different sides of the evictions spectrum, as it were. So Greg's evictions are substantially different to mine, substantially different to the type that Selma does. But every so often there's an overlap. There's specific overlaps in areas where things start becoming difficult. There's overlaps in reactions, especially when it comes to sheriff's reactions and the like. So from my side, I've started noticing a bit greater difficulties in areas that I wouldn't expect. And obviously it comes with, it normally comes with a price tag, and that's one of the concerns. So more often than not, it's not a situation necessarily that, so just to give context, we've got a specific property in an area where we were advised by the sheriff that they alone cannot do this eviction. In fact, it is going to be an extremely difficult eviction. And now, especially with COVID, we're starting to get into situations where people are trying to rely on the regulations to say that they should be staying on the property, even though there's an eviction order. So we all know that that's of no consequence. But they're now forcefully trying to stay on the property. And in the past, there's always been certain areas, and Greg would know this better than most, where there's great difficulties. But now we're starting to see that these are extending slightly into unusual areas. And unfortunately, it's starting to get to a point where clients are having to put up money, for example, to pay the RedAnts to execute some of these evictions when typically they wouldn't have to. And that comes at quite at a cost. And yeah, so that's from my side. I'm starting to notice some sheriffs are being reluctant to execute these evictions without the assistance of the SAPS and RedAnts, which isn't always available to them. But it is very specific areas. So your general run-of-the-mill lease agreements are still going relatively well, save for the fact that we're struggling with getting dates. Greg, from your side?
Start at the end, struggling to get dates. There's been this disjuncture between the previous set of practice directives and the new ones. So it's all well post the new one, but they didn't deal with the interregnum at all, it seems. So that is a constant fight. My colleague Colleen, that Bruno knows, is tearing her hair out and trying to get matters set down. It's a bit hit and miss, isn't it? You kind of think you got a date and you set it down. You mostly have, but it's not completely certain. Yeah. So it's all a little inadequate. And I also heard today that there seems to be an attempt to close very early in December and open very late in January. I don't know if you picked that up as well.
No, I didn't pick that up today, but that's ludicrous.
Ludicrous. 25th of January, someone suggested. It can't be right. It can't be right. But anyway, we'll I'm sure talk about that in the future. But Bruno, do you find, or same with you, Marley, do you find that most of the sheriffs outside the inner city tend to do evictions themselves as opposed to using external contractors like the RedAnts?
Okay. That's definitely from a lot of most of the suburbs, except the inner city ones and some of the ones that go out into the further reaches. So if you go to example in Pretoria and your Greater Tshwane area, it's different. But your general Pretoria, the sheriffs do it themselves. They contract their own laborers, but laborers is a different story. They still go out and execute. I mean, I was having a chat with Theo from Halfway House the other day. So even in your Alexandra, he's still
No, they do it. They do it very well. Yeah. Yeah, no, for sure. I just, obviously the bulk, I suppose the bulk of ours are kind of inner city or proximate, and it's always a fight. And sorry, let me rephrase that. It's not always a fight. It used to always be a fight. 15, 18 years ago, there was routinely a battle, literally a battle. Occasional gunfire, etc., when you emptied an inner city building. Happily, it's no longer the case. That's very much the exception now, not the norm, because no one won those fights. The problem is they didn't win the fight because there were 200 or 300 RedAnts, and an organized force is going to beat a rabble any day. The problem is, of course, it comes at such a massive cost. And it's all very well spending 150,000 Rand or more on a large inner city building, but spending 30,000 Rand on a suburban house is disproportionate to the benefit in using the RedAnts or similar. So that's the downside. And you mentioned earlier that you're having that problem now where people are aggressive and happy, threatening to fight, even in sort of the more suburban areas. And the sheriff, you said, was nervous and wants that level of support.
Yeah, and it's not even 30,000; it's 54,000.
What is it?
Yeah.
No, it's crazy numbers. I mean, it puts our costs as lawyers into the shade, and I understand the risk and understand the drama, but it does seem disproportionately massive. You've got to consider the value of the property. I always try and keep in our own costing some eye on the yield of the property. It's one has to bear in mind, is it a 1,500 Rand a month rental, or is it a 30,000 Rand a month rental, which obviously has a bearing. Is the poor client going to lose 3 months worth of income or 2 years worth of income? It's something we obviously try and keep in mind.
Balance
so yeah, that has been tricky. The inner city sheriffs came up with the idea wrongly that they can't conduct an eviction without the direct instruction of the court, or it was suggested the authority of Mrs. Nkosazana Zuma, Esquire, if that's the correct word, which, it's just ridiculous. The fact is that the regulations, while clumsy, are clear. But
absolutely.
I sent them a letter today. We engaged with the state attorney, who's represented the minister in this debate, and he says, no, of course you can conduct an eviction. There's no prohibition at all, as long as there's an eviction order, as long as the date's passed. It's not like it was under level 4.
So out of interest, is your struggle with the fact that you have eviction orders pre-COVID that never fathomed the idea that COVID would ever exist? So no dates were ever specified, and there was no specification as to after state of disaster or after level 1. It was just an open-ended eviction order that now people don't want to execute because they feel that the rules somehow suspend its operation.
Correct. It's the ones that go back to February and March, where we didn't contemplate lockdown. The others where they were maybe granted under level 4, where the regulations kind of misled us into thinking, well, at the end of level 4 or the end of level 3, we'll be able to proceed as before. So there are a number of orders, I'm sure you've dealt with them, that basically said at the end of level 3, but subject to national lockdown. Yeah, sort of the awkwardly worded ones.
Absolutely.
I think mostly the ones granted during lockdown are fine. Some of the more recent ones in the last few weeks, they're going to say, end of October, end of November, because we are out of the hard lockdown part. And but I think the ones the tricky ones I'm dealing with are the ones from February or March, including orders in the urgent court that we then couldn't execute, and we haven't been able to get the courts to you know, to engage. I wrote to the presiding judge recently, last week, and I said, you know, you granted this order, you dealt with the issue, you gave the order in the urgent court that people vacate. Now the sheriff is saying he can't evict, which is obviously wrong, and suggesting an amendment to the order. But you know, it's unusual. It's very unusual for a judge to engage in a matter once the order has been granted. But
Absolutely.
we are left with no alternative.
Yeah.
I even tried to get a warrant of ejectment premised on the current state of lockdown, but we got the same nonsense from them. Oh no, you can't evict at the stage of lockdown. It's level 1, bro. You know.
Yeah, so that's what we try to one of the matters. That's what we try to one of the matters as well. If memory serves, we were successful with it because there was one sheriff that was giving us trouble. Now I can't remember the exact reason why, but it was along the same lines that they felt that whilst we're in the state of disaster, it needs to be expressly stated in a court order that you are allowed to evict. Otherwise, it's deemed to be suspended until the state of disaster. So obviously we all, you know, so they have that opinion, we have a different opinion. So we try to almost refresh the order by getting the warrant. And if memory serves on that one, it worked because at least then it had today's date, and it was like the registrar said, "Do it now." There you go.
Sure.
Please do it now. Yeah.
Sure. Was that High Court?
Yeah.
But
it wasn't my matter, so I don't have all the facts, so I can't remember exactly what happened. But that's how I recall it happening. Maybe the warrant wasn't issued, but there was a conversation about taking the warrant to court. They spoke to one of the registrars who seemed to agree that it should be issued. I just don't know whether it finally was or wasn't, because also getting things in and out of court is a bit of a mission. I sent one of my clerks there the other day. She sat there till 3 o'clock waiting for someone to come back from lunch. And she got there at 11. So this was one hell of a lunch.
Well, there was a time earlier on, probably May, when the courts were closing at 2 o'clock. People were going home at 2 o'clock, but they still took their 1 o'clock lunch break. I mean, you know, seriously. The public sector's got to catch a wake up.
Look, I suppose
longest paid holiday in history.
Yeah, and I suppose that's the issue that now with the dates and recess that I'm worried about. Everyone is making it up. If you look at some of the schools, I don't know about public schools, I haven't checked, but like private schools, they're starting to take away chunks of holiday to say, listen, we need to finish the curriculum like decently, so we don't want to rush people through it. And these are small kids, so it's not even just you know, like matriculants. And everyone's making plans. We're adjusting. Even from my office, we're pushing up closing date so that we can you know, use December as much as possible to finalize matter, write up the necessary fees, that sort of thing. I wouldn't imagine that, you know, now the December break would be made longer for anyone, because that wouldn't make any sense. We've lost half the year.
Look, I mean, a little side rant. It seems to me that these court directives, the courts, to me, for the entirety of my time in practice, have been trying to export more of the burden onto attorneys and away from their own administration as they possibly can. And it's all very well, because attorneys are generally going to pursue it and do it and achieve it. But there's a cost. And you can't go back to client and say, well, now we have to do this and this and this, because no one in the court wants to work. They're trying to make the practitioner do everything. And it's coming up to the time when the line needs to be drawn on the directives in particular. The rules are fine, the law is fine, but these directives are exporting more and more of the obligation to the practitioner at the client's burden. And, you know, Section 34 of the Constitution is going to have a word very quickly, I'm afraid.
No, absolutely. And I mean, there's a lot of things. I mean, now to digress, but I mean, even if you look at the foreclosure rules.
Oh, God.
It's, I mean, if you speak to the people from the banks, they're just like, it's just not worth it. They don't know what to do. They're actually desperately, jump through every hurdle.
If you get a foreclosure, because quite often, and I'm sure it's the same with you, we end up having to evict people who are in foreclosed properties. And the one thing I know, that if someone has got a foreclosure order, it's perfect. It is golden, because you do not get foreclosure orders unless you have jumped through every hoop, backwards, in triplicate, perfect score times 10 every time, you know?
No, absolutely. And then the worst part is, it's now not even just getting the order. So getting the order, you know, you follow a certain process and you're likely to get it at some point. The difficulty we're finding, and this is again the conversation that we had with the sheriffs, is the different judges grant different orders, saying different things on things, for example, like the reselling of the property. So if you don't get to a reserve price, what happens? And different sheriffs treat it differently. You're supposed to put it back up on auction for a second time. You're then supposed to take it for ratification. But if some sheriffs are doing it differently, and now you're getting buyers, it's gotten to the point where the confidence of buyers at auctions, when they put up the property for the second time, no one bids, because no one has any interest at all at waiting for ratification for a good solid. I think I've been waiting now for ratification on one of my matters now since January.
Crazy.
And
the problem is in the context of this forum, generally speaking, a non-paying tenant has caused this problem. This caused the foreclosure. Someone bought an investment property, the tenant wouldn't pay rent, foreclosure because they can't pay the bond. These guys sit pretty. They live there forever, happily, because the system, the foreclosure system, and then the eviction system on top of it are so time consuming. And well, as you say, don't even get to the sale in the end sometimes, you know, because and make no mistake, the people who live in some of these properties play this game properly. I mean, I've heard stories of them coming to the sales and trying to interfere with the sales.
Oh, no, absolutely. I've seen it plenty of times.
I'm sure you've seen it plenty, where, you know, just to undermine the sale, knowing that if you mess this sale up, months more free residence, and it's wrong. That's not appropriate.
Yeah. And I mean, remember how some of these sale and executions take place. So you also control the crowd. So the sheriff's job, like auctions are a science on their own. The sheriff's job is to rally the people, try get a momentum going so that you can push up the price, right? Forget value, get the price up. But there's also the downside to it, where there's also a lot of influence. So people that want to buy the property, or people that want to interfere. So we've had former owners and former occupiers attend auctions and spreading basic lies about certain things on the property, the condition, the amounts outstanding, and spreading this through the crowd to lower confidence, reduce bids, and then get to a point where the bank buys it in, and that takes even longer, because then the eviction's just never going to take place. They've got the property for a good solid, whatever, 15, 18 months.
Yeah. No, I get it. It's, I think, I mean, I don't want to just moan, and obviously our role is to find solutions, as we mostly do, but it's kind of, you know, every now and again, the sheer weight of the job we have to do needs to be relayed, you know. There's just...
Absolutely,
it's not easy. I think if it was easy, everyone would do it. The system does not help you. As the attorney, you have to push the system from the very top to the very bottom. And everyone in all of those processes doesn't want to do anything. And you have to make it work. And I once did a kind of time and motion schedule of an unopposed eviction. I think there were 25 separate items. To get an unopposed eviction order, you have to do 25 odd different transactions. And it's massive. And when the court starts exporting more of its own bureaucratic job onto the attorney, that number goes up. And obviously we are far too nice to increase our fees commensurately.
And then the worst part, I suppose, is then not only what we're required to do, but now we're also looking at things like the municipality. We're looking at COVID, the municipality, and courts just outrightly saying, we're not granting orders until we have that report. And obviously, like the case that took away the generic report, so that they took away and said, sorry, the municipalities can't just give out generic reports. They need to go out and investigate. Now try and get municipalities out to investigate, attorneys appointed, reports drafted, and all the person needs to say in the affidavit is make it the smallest averment. And it is disappointing because there used to be some very good judges on the bench. Obviously, no names mentioned, but I still remember approaching judges and even making the suggestion saying they cannot just ask for postponement, at least ask for a good reason. What is the valid reason for postponement? We cannot just hand out postponements when it's an eviction, go, oh, sorry, listen, I'm not ready. Okay, sure. And I still remember a couple of judges saying, yes, absolutely right. What's your reason? That's not good enough. And granting the order to my shock. But they granted it. And
no, for sure. It's sorry, Molly.
No, you can proceed, Greg.
Thanks. It's have you guys talked in my absence the last few weeks of the level 1 regulations, and the more particularly that subparagraph 2 with the stay and suspend, stay and pend element? Have we spoken about that?
I think we actually spoke about it with you when level 1 first came.
You're right. No, we did.
And then a couple of times over the week. So is there? Are you experiencing something new?
No, not at all. Not at all. I'm just I'm interested in the how do we put it? The ability, the relatively easy ability for a respondent to have execution pended, stayed, not pended. It hasn't happened to me yet. I don't know if it's happened to you guys. My gut feel is when the word goes out that evictions are happening, we'll see a spate of attempts to stay.
Absolutely. I think the one benefit, I haven't, but the one benefit is we kind of approached it very proactively. So we didn't take the chance. We actually kind of delayed some of our applications for a bit. The clients didn't like it, but they thanked us in the long run, because we then took the regulations, we really thought about it, and we kind of counted most of the things. So we went in, or not placing the onus on ourselves, but trying to dispose of it as much as possible and addressing it. And it paid off, because eventually no one gives us the right answers to fall within a suspension. We motivate why suspension would be like very prejudicial, and we seem to have come right. So I haven't really had, they've obviously given long periods of time, but I didn't land up with an order that said until the end of the state of disaster, whenever that might be. So they've given a 2-month order and a 3-month order granted, but we haven't ended up with a stupid order that could go until next year, June. Like, I'm worried winter come state of disaster still exists, and everything that's been pended is still suspended is still there.
No, I think our experience is the same. We are getting orders essentially as normally as before now, I think. It's especially in the last weeks. It's I think it's important to show and attempt to engage with the ex-tenant maybe a bit more. But then that's the end of it, So we've added an extra paragraph, maybe 2. But other than that, off we go. Same as before. I think we're definitely going to get into the opposed ones are going to come up before too much longer, and then things are going to get more complex. And I think the issue is going to be personal circumstances, which gets us back to the municipality, and they are going to have to be much more proactive in coming forward and investigating. Because I think what a lot of people are doing, a lot of tenants are doing, they're holding on to cash, believing that there aren't implications. So obviously there are many who are in trouble and don't have money, but there are many that do, but that are, hoarding their cash for whatever reason, believing that they can't be evicted at the moment.
It's like like the ETOL
correct,
saga.
correct. So I think that that needs to be unlocked, and that's going to be, the municipality is going to be key in that debate, I think.
I agree.
Definitely. All right, thank you for that. I think it's very important for our viewers to know that of the difficulties that we're having with the courts and the process and everything. So thank you, guys. And then
Hopefully this goes viral.
Yeah.
There's enough viral around. Sorry.
No problem. I just quickly want to discuss a body corporate question. So we've had a few queries about Airbnb owners that receive higher penalties than normal owners. So I just want to know if we quickly can discuss that. If you've had same queries, I think, Bruno, if you want to get started on that.
Yeah, so this was actually somebody that approached me regarding Airbnbs and body corporates, and this is an issue that's been kind of simmering for a really long time. I've had this conversation over and over. Now, what we need to realize is one of the difficulties is litigation isn't generally cheap. So we like body corporates sometimes have a bit of a fund that they can afford to go and fight people, do rental collections or try defend any litigation against them. But individual owners sometimes don't have that cash flow. So we've had a lot of Airbnb owners that have come with the complaint that they're being possibly alienated by some body corporates. The body corporates are trying to either do away with Airbnb or short-term rentals in that space, or now the most recent one. So it was always a question of, but conduct rules prohibit it. And my attitude was, listen, if you haven't bought in there yet, you're going to get a lot of fights. So maybe just don't buy in there. Don't go looking for a fight. Go buy somewhere else. If I happen to find a client in a situation where he owns something and now they try and introduce the rules, we've objected to it and it's worked. But now we're finding that it's no longer a question of saying, no, you're not allowed to do it and we can go object. They're trying, there's other ways. So there was now something along the lines of double penalties. So whatever a normal owner pays, so let's say, for example, parking penalties. Whatever a normal owner pays, they will now charge double that penalty to the Airbnb host. If for some reason one of their tenants or guests parks in the wrong place, or whatever other type of penalty. So that's one I can think of that directly correlates with people, but I can imagine there being quite a few. So yeah, so that's the new thing. So there's no specific answer. I just thought I'd put it out there because if anyone is having these issues, please let us know, because I would love to be able to take this on as a group. It's a lot easier than one owner trying to fight this himself, because then you're limited on what you can spend, whatever the value of counsel or which attorney goes to court. It would be nice to have 2-3 people that we can run very similar cases simultaneously, do the research simultaneously. It's doubtful that we'll have them all in the same building, but at least we have the knowledge to be able to service 3 different clients and be able to spread out the costs against whichever way the outcome, whichever way the outcome lies. At least we'd be able to split those costs.
Okay, thank you so much, Bruno. Greg, do you maybe have anything to add to that? And,
concur with Bruno.
Perfect. All right, do you guys have any last thoughts, anything interesting happening at work in the past week? I think it's almost about the time that we have this evening.
Yeah.
So Dante, if you want to add something.
No, I think it's very busy. I'm sure that you guys are also busy. I think people's patience has run out with defaulting tenants, and I think they are now ready, willing, and in fact need to take steps as they are doing. We are not seeing land invasions, but we're seeing those construction mafia things happening again, where people blockade businesses claiming a right to payment or exorbitant contracts, whatever the case may be. And of course, we have an election year coming up next year, so we can imagine that things will get quite exciting come December when land invasion season starts.
Definitely. Bruno, do you maybe have anything to add?
Oh no, it's a pleasure having Greg on. I hope to see him next
Thank
week.
you. I really will try. Sorry.
I'll send you a reminder in the morning. I'll start calling you.
Please do. I love it when I do get on. Normally what happens, time goes by. Ooh, I missed that. That's, I'm afraid, how it is. I do apologize. I do aspire to joining you every week. And I do, as I say, I do love it when I am here. Thank you.
No worries.
Oh, shame. No problem. And thank you so much, guys, Bruno and Greg, for joining
Thanks,
us.
Marilee. Thanks, guys.
Yes.
Cool.
And then to all our viewers, have a lovely week and keep safe. All right.
Thanks so much.
Okay,
Thank
bye.
you.
Bye.